Sound check, 1, 2, 3. Sound check, 1, 2, 3. Check, 1, 2, 3. Mic test. Test, 1, 2, 3. Mic test.
Good afternoon. Good afternoon po. We will start in 2 minutes. Please settle down. All right, good afternoon, everyone. Let's start this afternoon's plenary session or plenary session 2. All right, please settle down. Can we please close that door? Thank you. Okay, magandang hapon po sa inyong lahat. Good afternoon, everyone. I am Attorney Reyna Tan Francisco, Chief Judicial Reform Program Officer of the Project Development and Resource Mobilization Group of the SC Program Management Office, and I shall be moderating this afternoon's plenary session. Okay? The session is entitled Addressing Congestion Through Criminal Justice Reform in Brazil. Okay, that's Brazil daw in Portuguese, no? I was coached by my speaker. In Brazil, important lessons from the Global South. Okay, let me call on our keynote speaker, the Honorable Gabriel da Silveira Matos, Associate Judge, National Council of Justice, Brazil. Your Honor. And we have 3 reactors. First, I'd like to call Supreme Court Associate Justice and Chairperson Subcommittee on the Revision of the Rules of Criminal Procedure. We have with us this afternoon the Honorable Rodil V. Salameda. Sir, Your Honor, dito na po. Thank you. Another reactor is Jail Senior Superintendent Roy P. Valenzuela, TLPE, Chief of Staff of the Undersecretary of Public Safety, DILG. Sir? Wala pa si Sir. Okay. Another reactor we have from the Integrated Bar of the Philippines, or the IBP, its President, Attorney Antonio C. Pido. Ayan na pala si Sir. All right. So I think we're ready to start. Judge Matos, who traveled, according to him, he traveled 1 day, or 1 day and several hours to get here, ma'am. Go ahead, Judge.
Okay. Good afternoon. Ladies and gentlemen, I would like to thank UNODC for this invitation, and I would like to thank the greatest expertise or expert on the Brazilian prison system, Judge Geraldo Lanfredi, my friend, and I would like to thank the Justice Ministro Roberto Barroso, the President of the Brazilian Supreme Court. Magandang hapon po. Please, the presentation. Okay. Brazilian experience with prison overpopulation. Who I am? My name is Gabriel Matos. I have been a judge in Brazil since 24, where I have worked alone in small towns and even assistant justice of important courts such as the Federal Supreme Court and the Superior Electoral Court. Portuguese is the language spoken in Brazil, so forgive me for my bad English. What am I going to talk about? Brazil, the organization of the Brazilian state, problems with the prison system and who should help solve it. The executive branch creates prisons but is unable to solve the problem on its own. The legislative branch's contribution to tackling the problem, the role of the judiciary in the solution, and the recent measures adopted. And the conclusion. Where do I come from? I come from Brazil, a country located in South America. Brazil is on the opposite side of the globe from the Philippines. After India, Africa, Atlantic Ocean, okay? And here, Brazil. It's south of the United States, you know. Riches, contrasts, and challenges. Images speak more than words. Look, this is Rio de Janeiro city. It's a great city in Brazil. Beautiful. Iguaçu Falls. São Paulo, a great city like Manila. Important people from Brazil. Pelé, Ronaldo, football players, Gisele Bündchen. Brasilia, the capital of Brazil. Brasilia too. São Paulo. Santos Port. Port again. Refinery, oil refinery. Olinda. Bahia, Salvador. Salvador again. São Luís. Ouro Preto, the center of Brazil, capital of the gold. Important road to the beach in Brazil. Mountains. Iron mine, great iron mine in Brazil. Soy. Mountains. The rainforest is in Brazil. Amazon forest. Here I'm going to work in the Amazon forest with army, indigenous people. This picture is mine, picture mine too. Pantanal, indigenous people, much various. Desert, or like a desert. Another, a cave, great caves. Rio de Janeiro again. Copacabana Beach is a famous beach in Brazil. And the contrast, look at it. People live in the mountain. The name is favela, this kind of community in Rio de Janeiro. Children. Children lives near garbage. Yeah. Brazil is the 50th largest country in the world, behind Russia, Canada, United States, and China. Yeah. Covers 8 million square kilometers, while the Philippines covers 300,000 square kilometers. Therefore, the Philippines is about the size of a Brazilian province called Maranhão. Look, Filipinas there, and the size of Filipinas in Brazil, yeah? But although the Philippines has a much smaller area, its population is half that Brazil. Brazil, 200 million people. Philippines, 100 million people. Therefore, population density is an important difference between the Philippines and Brazil. Let us now move on to discuss a little about the organization of the Brazilian state and then the prison reality in my country. Brazil is a democratic republic, and its current constitution was written in 1988. It divides the power of the state in three. What is it? Executive, legislative, and the judiciary branches. The rules of criminal law and criminal procedure are enacted in the form of law by the legislative branch. Some individuals' rights written in the Brazilian Constitution. No one will be arrested without due process of law. No one will be found guilty before the final trial. The sentence will be served in establishments according to the crime, age, and sex of the convicted person. Prisoners are guaranteed respect for their physical and moral integrity. There will be no death penalty or life imprisonment. Habeas corpus will be granted to anyone who suffers restriction of freedom due to an illegal act. The judiciary is made up of judges and courts located in the various provinces as well as higher central courts. The current federal constitution innovated with the creation of a central body with disciplinary and administrative competence over all other judges except the Supreme Court. This body is the National Council of Justice, where I work, popularly known as CNJ, located in the capital of Brazil called Brasilia. I was Secretary General there last year. Today I am an assistant judge to the president of the council. This council, in its administrative competence, can issue regulations on the organization of procedures, regulate national electronic system, supervise the administration of the courts, among other expertise. Now, problems with the prison system and who should help solve it. In Brazil, the law determines a difference in treatment between adolescents and adults. The criminal sanctions are different and the place of detention is separated. Adults deprived of their liberty now, 60 and 1,000 adults and 12,000 adolescents. PDL, yeah? Then, Brazil is the third largest prison population in the world. Any details? 5% are women, 30% are remand prisoners. Only 30%, not so much. Following the current ranking of prison population statistics in the world, according to the website prisonstudies.org. The information about Brazil is a little out of date, but the order remains the same, okay? Look, this is the ranking, world ranking. United States is the first, 1,007,700. China, second, Brazil, India, Russia, Turkey, Indonesia, Thailand, Mexico, Iran, and Philippines. Philippines is the 11, yeah? Let me clarify that this is the exact total of prisoners in Brazil, not 800,000 as stated in the prison studies report. This divergence may have occurred because in addition to these prisoners, we have another 190,000 people who have the status of prisoners, but who are under house arrest. That is, they remain in their homes and do not occupy places in prisons, and by the previous criterion were also counted as prisoners. We have already reported these to two prison studies. Since 2017, after surpassing Russia, Brazil has occupied third place in the absolute number of people imprisoned in the world and has the highest rate in the South America, 357 of prisoners per 100,000 inhabitants. Between 2015 and 2018, there was a decrease in the prison population in China, United States, Russia, and Mexico. But in Brazil, there was a big increase. This is the graphic, and the blue is the normal population. the left side, the number. And red is the prisoner or PDL population. It's a normal after 2015. Then after, with pandemic and another measures, it's down. The executive branch creates prison, but is unable to solve the problem on its own. In Brazil, the constructions and administration of prisons is the responsibility of the executive branch. There are currently 1,400 prison units in Brazil. Some are excellent, and the others are terrible. Look. And look now. The problem. Yeah? Much people. Yeah. Like Philippines? No. No. It's Brazil. Okay? All Brazil. Look. Today in Brazil, there are 650,000 prisoners, but in reality, the system capacity is 480,000. The historical comparison between the number of prisoners and the number of vacations in prisons shows that even with the constant construction of new places in the same proportion as the growth in the number of prisoners, there is still overcrowding. Look, blue line is the number of PDL population. And the brown line, yeah, or yellow, brown, the places. And the red line is the deficit. All lines growing, yeah? Prison overcrowding has caused numerous internal and external problems: violation of prisoners' human rights, the coexistence of prisoners convicted of serious crimes with prisoners convicted of minor crimes, or worse, pretrial detainees. Prisoners live worse off than when they entered. The inability of the state to manage the internal prison environment in an organized way. Constant internal conflicts causing aggression, abuse, riots, and death of prisoners or prison officers. The spontaneous organization inside prisons of factions, gangs, or criminal organizations that operate even outside prisons. The abduction of the weakest prisoners by criminal organizations, turning them into soldiers of crime and feeding the system again. Now, the legislative branch's contribution to tackling the problem. In Brazil, there are strong debates in society and in the legislative branch about war on drugs policy, treatment of drug users, and penal alternatives. Drugs are harmful and must be combated or their use controlled. This is a fact. But would legislative action alone to criminalize trafficking and use be enough? I don't have the key to the answer, but I don't think so. The war on drugs to arrest criminals has led to overcrowded prisons as well as many deaths. Look, the war, drugs war in Brazil. Rio de Janeiro, too. Every week. like a war, yeah? My experience as a magistrate in medium-sized town, where we had a very efficient police force that was able to arrest all the drug dealers in town, was interesting. The next day, there was already a dealer from the neighboring town selling drugs in my town. I think there are other components to this drug problem equation. Trafficking and using drugs can be considered a crime, but there is the economic factor. Where there is a consumer, there will be a seller. There is the health factor. If there is a chemical dependence, the drug user will continue to use. There is an educational and social factor. Less information and opportunities makes the access to the world of drugs easier. So I think the war of drugs policy should be reviewed and improved without prejudice, and it's up to the legislative power to have the courage to tackle the issue and listen to experts in all areas. And in Brazil, the issue is under constant debate. Since 2006, the crime of drug use has not led to jail time under Brazilian law. Only the following measures and applied to the user: a warning about the effects of drugs, community service, and educational measure of attending an educational program or course. The problem of lethal drug users is very serious. In large cities in Brazil, there are places where they are effectively congregating and living on the streets. Look again. People live in the streets and using drugs is a problem. Great difficulty. It's in São Paulo. It's a very difficult problem to solve. But I'm sure of one thing: criminalizing drug trafficking and use alone won't prevent it. In short, these are challenges that the legislative power must address because they directly reflect the problem of prison overcrowding, since around 30% of all prisoners are held for drugs. The Brazilian legislative branch has already taken other measures recently, 2019, by amending the criminal procedure law, determining that arrests can only be made in flagrante delito or by decision of the judge for conviction and or preventive detention. Upon arrest, the accused must be brought before a judge within 24 hours for a custody hearing. The judge is obliged to decide on the maintenance of the arrest and the reason for not granting an alternative measure, such as periodic appearance in court, inform and justify activities, ban on access to certain places, ban on contact with a specific person, a ban on leaving the district, home confinement at night and on days of when the investigated or accused has a permanent residence and work, suspension from public office or economic or financial activity, provisional internment when experts conclude that the person is incapable of committing crimes, bail in offenses that admit so, electronic monitoring. It's important. Every 90 days, the judge must review the decision or imprisonment presenting a justification. Now, the role of the judiciary in the solution and the recent measures adopted. Judiciary. Specifically, with regard to the judiciary, two actors have contributed to change of course to help improve the Brazilian prison system. Administrative measures adopted by the National Council of Justice, CNJ, and judicial measures adopted by the Federal Supreme Court, STF. First, administrative measures. 25, creation of the CNJ by a constitutional amendment, discipline the national judiciary and establish general administrative rules. The President of the Supreme Court is also President of the National Council of Justice, where I work. 29, creation of a Department of Prison Monitoring and Inspection, DMF, within the CNJ to supervise jails and criminal judges, obliging them to periodically inspect jails and to judge prisoner cases quickly. Constant inspections of prisons throughout Brazil, producing reports and presenting to society the conditions and making it clear that the person treated in this way will probably come out worse off when they leave. 2019, beginning of the CNJ's international legal cooperation with the United National Development Program, with the Present Justice Project, with the support of the Brazilian Ministry of Justice. The project currently continues under the name Doing Justice. This is the name in Brazilian, in Portuguese, Fazendo Justiça. In 2019, partnership with the United Nations Office of Drugs and Crimes, UNODC, to implement custody hearings. It's important to note that the international cooperation agreement between the National Council of Justice and the United Nations Development Program, UNDP, through which the Brazilian state contributes research and UNDP provides technological support, was and continues to be a very important negotiation for carrying out these various actions in the prison area with the Doing Justice program. This agreement is formalized in accordance with Brazilian laws, and the Brazilian Ministry of Foreign Affairs also participates in it. Here is a folder of the Doing Justice program with the actions being implemented by the CNJ with the support of UNDP. Administrative measures, CNJ. The CNJ's ongoing Doing Justice project is concerned with three main fronts in the prison area: entrance door, permanence, and exit door. Entrance door, careful screening non-entry, replacing detention with another measure whenever possible. These actions. Permanence, improved living conditions in prison, school and vocational education. And the exit door, exit in better conditions than entered, personal documents in order and social development. It's also important to note the essential partnership between the CNJ and the UNODC, especially when it helped the judiciary to qualify judges in the implementation of the custody hearing. Another administrative measures, creation of IT systems and other measures, a single national standard for numbering cases and cases types. Because Brazil is so big, yeah? Electronic judicial process. Cases in Brazil are now digital and no longer on paper. There are currently 80 million cases in progress. A national bank of arrest warrants. Every record of arrest or release is entered into the system. An electronic penal execution system. The entire process of serving a sentence is electronic and generates warnings when the prisoners reach their progression of release dates. and the National Register of Inspections. Every criminal judge is obliged to visit the prison every month and fill in a system, 1 day a month. Here are another measures, issuance of various regulations standardizing mandatory procedures for all judges. Now, let's see judicial measures adopted by the Federal Supreme Court. In addition to the administrative measure adopted by the CNJ, the Supreme Court has also ruled in numerous collective and binding cases, taking measures to try to reduce overcrowding. Obviously, the Supreme Court does not fail to apply the law. It has simply come to consider that imprisonment in some situations, although justified by law, generates an unconstitutional consequence. This is what has been called an unconstitutional state of affairs. This is a balancing of constitutional principles within the judge's interpretive space, which makes it possible to recognize, for example, that an elderly person or a sick person imprisoned in the conditions currently offered will have a much greater damage to other fundamental rights than the more restriction of freedom that will be the measure applied. In this case, it's a case of house arrest. Violation of the prisoner's conditions can lead to a return to ordinary prison. Okay. Brazilian Supreme Court, it's important to clarify that the Brazilian Constitution, this is the Brazilian Supreme Court, important to clarify that the Brazilian Constitution provides that the Supreme Court can judge in addition to individual case in which there is a debate on constitutional rules, some types of collective actions that can only be proposed by certain people or organizations, in which the constitutionally or inferior laws or even the state's failure to supply or guarantee an individual right provided in the Constitution. These actions are known by the acronyms ADI, Direct Action of Constitutionality and Constitutionality, ADC, Federal Declaratory Judgment Act, or ADPF, Claim of Non-Compliance with a Fundamental Precept, and their judgment applies to everyone. ADPF 347 to 2015, the most important STF decision on prisons in recent times was this ADPF. Legal norms support urgent measures to tackle overcrowding. The decision is based on international and national sources. The federal constitution states that no one shall be subjected to torture or inhuman or degrading treatment. There shall be no cruel punishment, and prisoners shall be guaranteed respect for their physical and moral integrity, is the Constitution ruled. And all these rights can be seriously violated in the context of overcrowding, which places it at the center of the protection of fundamental rights. The expression unconstitutional state of affairs comes from a precedent set by the Colombian Constitutional Court in sentence T388 of 2013. Based on the Colombian parameters, the Brazilian STF recognized that the situation when three main assumptions are present: a situation of generalized violation of fundamental rights, inertia of or repeated and persistent inability of the authorities to change the situation. Overcoming the situation requires the action not just of one body, but a plurality of public institutions. The Supreme Court stated that these conditions were present and that it was responsible for imposing on the public authorities to take urgent and necessary actions to remove the massive violations of fundamental rights as well as to supervise the effective implementation. In this decision, the justice recognized that the prison overcrowding had occurred, with the prison deficit exceeding 206,000 places. The problem of overcrowding, which can be source of always, is striking. The Supreme Court recognized, based on the report from the legislative power, that overcrowded cells cause insalubrity, diseases, riots, rebellions, deaths, degradation of the human person. A scenario that would only allow the conclusion that there is a generalized violation of fundamental rights in relation to dignity, physical health, and psychological integrity, pointing out that prison overcrowding and the precariousness of the units, in addition to being an affront to the legal order, constitute degrading, outrageous, and undignified treatment of people in custody. He clearly states the custodial sentences applied in our prisons have become cruel and inhuman. Prisoners become garbage, worthy of the worst possible treatment, being denied and our rights to a minimally safe and healthy existence. I would like to clarify that the Brazilian Supreme Court has adopted the concept of unconstitutional state of affairs, which originates in the case law of Colombian court. It is normal in Brazil to adopt theses or theories from other countries as secondary sources of law to reinforce the foundations of judicial decisions, provide, of course, that they harmonize with Brazilian constitutional principles. Here you have the summary of the main recent decisions. These are the PF 2016 Biden Precedent 56. If there is no vacancy in the appropriate prison regime, the sentence must be served in the next lighter one. And clarify, Brazilian law has closed semi-open and open sentence regimes. 2017 extraordinary appeal obliges the state to compensate for damages, including moral damages proven to have been caused to inmates as a result of the lack or inadequacy of legal prison conditions. 2018 collective habeas corpus, order to replace pretrial detention with house arrest for pregnant women or mother of children up to 12 years old or people with disabilities. And 2020, another collective habeas corpus extend the previous measure to all prisoners who at home are solely responsible for people in the same situation. Here you have the same graphic, but with the measures of CNJ, CNJ, and STF. Of course, in 2019 you have a pandemic, but the curve is slowed down now. Yet. Okay, the conclusion, finally. The precarious treatment of prisoners implies a violation of fundamental guarantees that go beyond the limits of the sentence imposed. The poor treatment received by prisoners is often what they give back to society when they are released, becoming more violent and cruel and leading them to commit more crimes. This difficult life situation in prison has generated a process of self-organization of the population into factions or gangs that have acted not only inside the prison, but also outside it. The increase in incarceration in places where there are no more vacancies makes it easier for these gangs to recruit more people who come to depend on them. We are thus, in some indirect way, helping to create criminal organizations. Improvement requires the state to coordinate and organize itself better than organized crime. It requires a joint effort between the legislative, executive, and judicial branches, society, universities, national and international organizations, and the private sector to find intelligent and creative solutions to tackle the problem. Improvements will come in the long term, okay? I will end with the conclusion that any change requires first shedding light on the problem. I think that's what we are doing today. And that's what the Justice of Brazil Supreme Court have been trying to do for some years now. Here are photos of some of them visiting prisons. President of Supreme Court, this lady too, another justice, the last. Now, links to publication in English about the Brazilian prison system. Okay, I have much books in English. Links, videos to electronic monitoring, okay? A resolution of the National Council of Justice on custody hearings in English. After I disponibilize. Okay. Links to official websites, Brazilian. My card. Thank you all very much. Salamat po.
Maraming salamat, Judge Matos. And now, we have 3 reactors who will each have 10 minutes, no, to give their reactions. I'd like to start with Associate Justice Salameda. Your Honor, please.
Thank you. On behalf of the Supreme Court of the Philippines, I would like to express our profound appreciation to Judge Gabriel da Silveria Matos for sharing with us his valuable insights on Brazil's experience in dealing with its jail congestion problem. It is truly remarkable to learn from Brazil's best practices in solving a problem we similarly face. As with Brazil, jail congestion remains to be a persistent problem in the Philippines. As noted, the World Prison Brief ranked the prison population of the Philippines at 11th, while Brazil is ranked 3rd. Considering how land areas and space are closely related to the issue of jail congestion, the Philippines may be in a more dire situation due to the geographical difference between the two nations. It is reported that 70% of the detention facilities are overcrowded at an average congestion rate of 386%. The majority of PDLs under the BJMP custody are merely held for preventive imprisonment. Even with the difference in our statistics, we can draw important lessons and strategies from Brazil's experience to address jail decongestion in the Philippines. From today's presentation, it appears that both Brazil and the Philippines, the poor living conditions of PDLs due to overcrowding is truly heart-wrenching. And actions must be taken, nothing short of a concerted effort will suffice. On that note, let me first highlight the systematic approach taken by Brazil to address its problem of jail congestion through the Programa Fazendo Justiça. This program shows that frameworks and approaches need to be calibrated so that there is consistency in government efforts. This can also be gleaned from the discussion of Judge Matos on the executive, legislative, and judicial components of their approach to solving jail congestion. Truly, this National Decongestion Summit, initiated by the JSCC, is a step in the right direction. Well, the transfer of inmates commencing in 2024 until 2037 from the new Bilibid prison in Muntinlupa, which shall be eventually closed in 2028, transferred to other penal institutions already existing and to be built, is a laudable effort. However, this will take time. Thus, we should put in place judicial systems and strategies that can help solve this problem at the outset and in the long term. So, on Brazil's Doing Justice program and our Supreme Court's initiative towards jail decongestion, let me preface my insight by stating an important difference between the judiciaries of Brazil and the Philippines. The Philippine Supreme Court is vested by the Constitution with the power to promulgate rules concerning the protection and enforcement of constitutional rights, pleadings, practice, and procedure in all courts. This is not the case in Brazil, since its rules of criminal procedure are enacted by the legislative branch. Our constitutional mandate enables the court, our Supreme Court, to take a more active role in promulgating important procedural rules that could potentially alleviate jail congestion in the country. On this score alone, we can say that we are better situated than Brazil. With this in mind, I will now discuss my insights on specific aspects of Brazil's Doing Justice program. First, Judge Matos presented that the Brazilian legislative branch amended the criminal procedural law for the conduct of custody hearings. This requires that upon arrest, the accused must be brought before a judge within 24 hours. This custody hearing is a procedural step that allows the judge to take a more active role in determining whether there is a basis for the arrest. This procedural step is within the ambit of the court's rulemaking power. On the basis of the Brazil experience, as the chairperson of the Subcommittee on Revision of the Rules on Criminal Procedure, we are currently discussing a proposal for a provision on custodial hearing, which is very similar to Brazil's custody hearing. This new provision was proposed by my colleague and the chairperson of the Steering Committee for Jail Decongestion Summit, Justice Monet Singh. This provision will utilize the alternative modes to preventive detention such as house arrest, compassionate release for the elderly and the gravely ill, furlough for pregnant women or nursing women, and other similar alternative modes to physical incarceration in a penal facility. Second, I also note the implementation of administrative measures by Brazil's National Council of Justice through the creation of IT systems. While our court has similar administrative circulars for the conduct of periodic visitation and inspection of jails by our judges, the same needs to be institutionalized for strict compliance on monitoring. The Philippine judiciary, through its strategic plan for judicial innovation, is currently in the process of adopting measures to modernize court and administrative process. Such IT systems can be useful in expediting judicial process to avoid needless delay that exacerbate congestion in jails. Third, I would like to highlight the judicial measures adopted by the Brazilian Federal Supreme Court to reduce overcrowding. I believe that the STF's recognition of the unconstitutional state of affairs of the Brazilian prison system and the imposition of measures on the executive branch was an essential step in furthering the rights of PDLs especially the right against inhuman or degrading treatment. It is in this light that the court is discussing the rules on writ of kalikasan kalayaan with the intent to give PDLs a remedy to rectify the current conditions of confinement of PDLs. Judge Matos also mentioned other STF decisions related to the jail decongestion efforts, such as imposition of house arrest as an alternative to imprisonment. Notably, in this jurisdiction, alternatives to imprisonment are also being implemented: fine, community service for light offenses. As can be gleaned from administrative measures of the CNJ and the judicial measures adopted by the STF, the judiciary plays a critical role in addressing the issue of jail congestion. Thus, the court is also unrelenting in our efforts to innovate and improve our rules and practices to aid in the reduction of prison overcrowding. On the revision of our rules of criminal procedure, the subcommittee on the revision of the rules on criminal procedure is in the process of drafting the revised rules with jail decongestion also in mind. It is considering reasonable certainty of conviction, a higher threshold of proof as distinguished from probable cause for the filing of information in court, to ensure that only those cases which have sufficient evidence to establish the culpability of a person will be filed in court. This can potentially lessen the number of individuals preventively detained, which account for the majority of detention in the country. One of the revisions also being studied is the proposal to institutionalize recognizance as a non-financial bail option, including the provisions of the Recognizance Act of 2012 in our proposed criminal rules of procedure. On jurisprudence aimed to aid in jail decongestion, the court is also actively enriching jurisprudence to solve the perennial problem of jail congestion. In People versus Monchero, the Supreme Court held that the plea bargaining in criminal cases is squarely a rule of procedure which falls within the court's exclusive rulemaking power. The court decreed that approval of plea bargaining proposal in drug-related cases involving small quantities of drugs is ultimately subject to the sound discretion of the court, allowing an accused to plead to a lesser offense and consequently may allow him to undergo probation if qualified instead of being put to jail. Also, on the application of GCTA or Good Conduct Time Allowances, upon request of the Bureau of Corrections to issue guidelines or clarification on the proper application of GCTA, the proper implementation is now being studied by the Supreme Court, and this will result in the eventual release of qualified PDLs, or at the very least, shorten their time in jails and prison, thus drastically reducing number of incarcerated persons. And finally, and perhaps the most important contribution in the jail decongestion effort is the active role of the Supreme Court in JSCC, the tripartite council composed of the DOJ, the DILG, and the Supreme Court. Indeed, jail decongestion is best achieved through coordination with other agencies sharing the same goal. JSCC, being the forefront of our battle, is reassuring. Today's summit alone is a testament to JSCC's commitment to remedy the ills faced by the justice sector. Indeed, as Judge Matos aptly concluded, poor treatment of prisoners can lead to a vicious cycle, creating more criminals instead of reforming and rehabilitating those incarcerated. The judiciary is steadfast in its commitment to help resolve this perennial problem of prison overcrowding. It also goes without saying that the other branches of our government are continuously innovating strategies and implementing their respective programs and projects to address jail decongestion. I hope that with these efforts, together with the support of international organizations like GOJUST and UNODC, as well as the European Union and the Australian government, we will be able to solve the problem of jail congestion in the country. Thank you very much.
Thank you very much, Justice Alameda. Right, let me call on our reactor number 2, Jail Senior Superintendent Roy P. Valenzuela for his reaction.
Magandang hapon po sa lahat. Good afternoon, Judge Matos. This is very inspiring because I'm from the BJMP and I've been a paralegal officer for more than 20 years. Very much familiar with the issues of congestion in jail. And I'm just I'm happy and thankful to Judge Matos for showing a very striking similarity in the situation in Brazil. That it reflects a lot of the same situation happening here in our own country. I would also like to thank him for giving us a quick tour of Brazil by showing a lot of pictures just a while ago. It's very reassuring that we are not alone in facing this problem. So while our situation is not very good, but at least there are many other countries facing the same challenges and situations. And it's good to have someone sharing to us the best practices that they were able to develop in their context, which may also be very much applicable in our own context. So this is, to me, this is very promising. But just would like to focus my reaction on only one point that Judge Matos mentioned a while ago. At any rate, most of the best practices that has been mentioned has already been reacted upon by the good Justice Rodin Salameda. So my reaction would just focus on the custodial hearing. To me, this is not very novel because I believe that in our country, in our rules, in the rules of court, we have very similar remedies that can be applied in order to reduce admissions or reduce intake. To mention a few, one of the provisions in the rules of court is the visitorial authority of judges in order to determine unnecessary detention, to prevent rather unnecessary detention, to check on the living conditions of the persons deprived of liberty, and to promote and maintain respect for human dignity of persons under custody. The other one is the power of the court to determine the existence of probable cause, which is discretionary. And the third one is the judicial authority to grant bail, and in some cases to find an alternative to detention, in particular or especially to the children in conflict with the law, which allows diversion instead of detention. So perhaps the difference is with the custodial hearing process, the exercise of judicial determination of probable cause becomes more or less mandatory, not just a matter of discretion, because to me, the greater challenge that we're facing concerning congestion is not it's actually less on fast-tracking cases, but it's actually more of an intake or admission issue. To me, the sheer number of law enforcers, 230,000 strong Philippine National Police, around 2,000 NBI, and a similar number of PDEA personnel, compared to 3,000 prosecutors, around 3,000 judges, 23,000 BGMP personnel. There is an evident imbalance in the structure. So I think this custodial hearing concept can be potentially give us a shot in the arm, because it deals with the intake issue. And this is especially true because of the arrest quota culture that we have before. So imagine having a lot of people making arrests, filing cases, and making the quantity of cases and the quantity of arrests as a performance indicator, then that puts a lot of burden on the other pillars of the criminal justice system. The other pillars are forced to take a case overload. The jail system is forced to take as many people as possible, but efficiency and effectiveness is actually compromised as a result because of the massive intake versus the low capacity of other pillars. So, of course, the congestion issue brings a lot of pain to our society, especially to the PDL and their families. And I see this as this custody hearing as an potentially effective filtering mechanism to weed out the unworthy cases, and for the criminal justice system to focus on the more worthy cases that will really bring justice and peace in our country. Thank you very much.
Thank you, sir. And finally, I'd like to call on Attorney Pido for the final reaction.
Good afternoon, Judge Matos. Good afternoon, Justice Alameda, Justice Singh, the Honorable Justice of the Sandigan Bayan, and other members of the judiciary, and to all my pañeros and pañeras inside this ballroom hall of Diamond Hotel. I was asked to be a reactor in my capacity as National President of the only lawyers' organization that is mentioned in the Constitution, and that is the Integrated Bar of the Philippines. So that makes all of you my members. I was asked to react because this organization was organized for three main purposes here in the Philippines: to elevate the standards of our legal profession, to assist in the administration of justice, and to enable us lawyers to perform our social responsibilities more effectively as an organization. And This is now our 50th year in existence. And we are glad to say that in those last 50 years, the Integrated Bar of the Philippines has tried its best to perform these roles. The Integrated Bar of the Philippines are all volunteer lawyers. No one is paid any salary in the Integrated Bar. But despite that, we are proud to announce that as of today, we have certified about 1,000 volunteer lawyers all over the country out of the 84 chapters performing voluntary free legal aid to indigent Filipinos. And it so happened that during this term of the officers of the Integrated Bar, from July 1st of this year to up to June 30, 2025, the IBP has made jail decongestion as its flagship legal aid activity. So, we arrived at that decision because so many of our chapters have experienced the sad plight of prisoners all over the country. So we thought that to leave a mark, the organization might as well try to help as many as possible to be released from prison, not to stay an hour longer than necessary in jail. So, last August 2nd of this year, the IBP launched its jail decongestion program nationwide. All chapters attended, around 200, a little less than 200 volunteer lawyers were present through a webinar or a conference. And then on August 29 of this year, the IBP held a conference with the Office of the Court Administrator, General Valenzuela of the Bureau of Jail Management and Penology, and from the Department of Justice. And we exchanged information on how to help each other. And we succeeded. We disseminated to the IBP chapters the circulars issued by the Philippine Supreme Court through its court administrator regarding the automatic release of prisoners, PDLs, who have already served the minimum imposable penalty for the offense for which the PDL is charged. We have also circularized the memorandums given to us by General Valenzuela of the BJMP regarding the treatment of PDLs. So, through these volunteer lawyers nationwide who do not receive any salaries, the IBP is proud to say that as of today, the IBP has helped around 8,190 prisoners already to review their cases, and to some, to assist them if they don't have any lawyer, because we just cannot intervene in cases where there is a counsel of record. To assist them secure their release. And so, with that, we hope that in the next 1.5 years, through its own efforts, this organization of lawyers here in the Philippines will be able to contribute its share and help alleviate the plight of prisoners in this country. Seeing the pictures that you have shown, Judge Matos, in one picture, Justice Salameda and I thought that we were looking at a picture of Quezon City Jail because similar. So, we share common experiences. What we will try to do is study whether it is possible for us here to adopt your concept of collective petitions for habeas corpus. I don't know if it will succeed here. Maybe you can give us your legal material so that we can study and see if it is applicable in the Philippine setting. Because petitions here of that nature have to be filed individually by every detainee. We hope that in the coming months or years, jurisprudence can be developed along that line. Also, your concept of unconstitutional state of affairs. I don't know, you did not say if there is a finding of unconstitutional state of affairs, whether it will result in simultaneous release of hundreds of detainees. I hope it can be done along that line. But those are lines of jurisprudence that still need to be developed here in this country. For a poor country like the Philippines, policymakers still have to struggle. Resources are limited, government resources are limited, and therefore, policymakers have to decide whether to allot resources for the poor people who are outside of prison, or allot the resources for people who are in prison. Because of millions of Filipinos who are below the poverty line, if we make living conditions inside our prison cells very comfortable, then it might create a situation that millions of Filipinos would rather go to prison because of the comfort inside. So it's a policy. It's a policy that has to be studied by our policy makers. Where to allot resources. A healthy balance has to be made for a country like the Philippines between alleviating the inhuman conditions of Filipino prisoners on one hand, and on the other hand, making people realize the difficulty of prison life so that it will discourage them from committing crimes. That is a difficult balance that policymakers have to decide on. But with that, one positive development that the Integrated Bar of the Philippines has already gained from this conference is we have talked to our Bureau of Jail Management and Penology, General Valenzuela, and also Undersecretary of the chairperson of the Board of Pardons and Parole. And we will try to help each other. Hopefully, when you come back to the Philippines, we can proudly say that we have substantially reduced the number of prisoners in our country, and we have substantially alleviated the conditions of our prisoners inside prison cells. Thank you very much, Judge Matos. Thank you very much, Coach.
Thank you very much, Attorney Pido. Would His Honor like to react, Rafa? Maybe for 3 to 5 minutes? Is no more? No reactions? Okay. Thank you so much. I have a few key takeaways. Yan, sumusunod ako kay Justice Monet. Sabi ni Justice, kailangan meron kayong KTAs man lang, ha, Reyna. Okay, reactor number 1, our good justice here, Justice Alameda, said, the Philippines may be in a more dire situation than Brazil in terms of the number of prisoners, considering our geographical situation. Now, we're smaller, but we are denser, or there's more, almost the same, half of their population. Actually, he said, Judge Mato said, will fit in a small province in Brazil. But Justice also said that the judiciary is taking on a more proactive role in addressing this perennial problem of prison overcrowding. So there is hope. Reactor number 2, General Valenzuela, said that he finds a certain familiarity with everything that Judge Matos presented, no? The measures that he presented, what the government of Brazil is doing to address the problem. And he also said that we have the same measures in place. For example, like the visitorial rights of judges, no? They regularly visit the jails, among other things. And finally, Attorney Pido said, what do you know? Jail decongestion is the IBP's flagship project. Okay, so parang everything is aligning. Okay, so to close this particular session, I'd like to quote something from a queen who is bigger than me, but has passed on. She said, for change to be effective, it must be gradual and imperceptible. Okay, thank you very much. Because we finished early, are there questions from the audience? Is there a question over there? It's too early for a break, sir. It is? So, I know that there's going to be game 3, and of course, I'm rooting for UP, okay? So, why don't we go straight to the launch? Look at your programs, please. It's supposed to be at 5, but we have time to spare. So may I call on Justices Mike Musngi and Justice Teresa Mendoza Arcega for the launch of the Jail Decongestion Summit logo and recognition of entries from PDLs. Justice Musngi, Justice Arcega, please. I'd like to thank you, Your Honors. You may go down. Sorry, nakalimutan ko po sila. Maraming salamat po sa inyo. Thank you. Thank you so much.
Di pa kayo makaalis, ano? Gusto niya na mag-break, mahigpit yung ating moderator. Good afternoon, everyone. We hope everyone had a productive day. And I'm positive, of course not with COVID, that all of us learned a great deal from the workshops that we had today. And later on, you will still have set of sessions. So before we have to announce first the winner of the JSCC's Jail Decongestion Summit logo and theme making contest. Pa-share yung winning logo, please. Alisin niyo yung mukha ko. Uy. Okay. So, actually, there are 183 entries, physical entries, and email. Emotional entries daw ang sabi kasi wala silang physical entries. So, without further ado, we are pleased to announce the winner of this year's Jail Decongestion Summit logo and theme making contest. Yan po. Mr. Dan Angelo Santos E. Borromeo from the Aklan District Jail Male Dormitory. The winners, there are actually 3 winners. It's in your kit in the souvenir program, nandun po sa likod. They will receive grocery items which will be given to the families of the winners. In recognition of the invaluable efforts of more than 180 PDLs all over the Philippines put into this contest, we proudly present their artworks in the gallery exhibit located outside of this hall, right beside the registration table. Have you visited the art exhibit? Pwede po kayong mag-bid dun sa mga artworks. Okay, so ang minimum bid po natin, 500 pesos, which we will give the amount to the PDL. So how will you bid? Please take note of this number. Pakipicturan, take a photo of the artwork that you like, and then mention there the bid. Kindly Viber it to 0917 140 0826. And tomorrow, before the end of the session, we will announce the winning bid. Again, it's 0917 140 0826. So, pakipicturan yung artwork that you like and send your bids. 500 po ang minimum. So once again, thank you for all the support to our common goal and effort to hasten and streamline the decongestion of our country's jails. To end, let us all direct our attention to the screen and watch the appreciation video of Mr. Dan Borromeo, the winner of this year's logo and theme making contest.
Thank you so much, Justice Arcega. It's only 3 o'clock. Diba? Bigla tayong hindi delayed, no? Advance pa tayo. So, ang mahigpit po naming suggestion, mahigpit na suggestion dumiretso na po tayo sa breakout. Yes? And then we will have your snacks served in your respective breakout rooms. So that after your session, you don't have to come back. Come back tomorrow, okay? But not this afternoon. You can go straight to the UP LaSalle game, which UP will win. Di ba? Yes! Okay. Woo! Wala ang Ateneo sa equation, ma'am. All right. So, pwede natin i-flash sa screen yung ating assignments uli. Workshop 5, Amethyst. Workshop 6, Onyx, Jade. Workshop 7, Citrine, Emerald. And Workshop 8, participants, please stay in the ballroom. Here. Okay po? Okay po? Yes? All right. Thank you very much. Pwede na po kayong magtuloy sa inyong workshops.
Apat lang. Kukunin ba yung mga baso? Oo, mga baso. Release natin. Tama ba? I-double check mo nga. Doon sa ulo. yung ano, yung ulo. Tama, tama.
Good afternoon, everyone. We will be starting with workshop number 8 shortly. So may I kindly request our participants for this workshop to move up to the front tables. Trust me, hindi kayo magsisisi na mag-move forward kasi marami tayong matututunan sa ating mga speakers. Okay, please settle down. So may we kindly request our participants for this session to settle down, to sit down so we can begin. The earlier we can begin, the earlier our day can end. Ay, sala. Good afternoon, everyone. I'm Jennifer Joy Siong from the Court of Appeals, and I'm here to moderate our workshop for this afternoon, which is workshop number 8, Decongestion Initiatives in the Justice Zones. So let me explain first what the Justice Zones are. The creation of the Justice Zone is the flagship project of the JSCC, and we are lucky to have here our mother of the Justice Zone, Justice Monette Singh, who really pushed for the creation of various justice zones. So what are these justice zones? These are areas where local justice sector actors, such as the police, prosecutors, public attorneys, judges, and prison staff, work together to identify common problems and generate common solutions to address them. So we are pleased to have with us this afternoon 3 very dynamic conveners of our justice zones who were able to find and create solutions to a main problem of our justice zones, which is jail congestion. So each of them will be given 25 minutes to discuss their various projects, programs, and initiatives which were successful in addressing this problem. So our first speaker for this afternoon is the convener of the Naga City Justice Zone, Executive Judge Pablo C. Formaran III, who has been a public servant for 34 years. I salute you, sir. He will discuss their initiatives of a transparency board, which was commended by our Chief Justice himself when it was first presented last year. So let us listen and learn from E.J. Formaran as he discusses with us Naga City Justice Zone's initiative on the Transparency Board.
Thank you, Justice Ong. Good afternoon to everyone. I have a short presentation. May yung PowerPoint. I was tasked to present to you the Naga Justice Zone's Transparency Board. And actually, this is a work in progress. Lately, we rebranded it to Transparency and Accountability Board to emphasize that we as justice sector actors in the justice zones should not only be transparent, but should also be accountable. And for a name recall, parang naisip namin, mas maganda yata yung Transparency and Accountability Board or TAB rather than Transparency Board shortcut TB. Mas maganda yung TAB yata. So, okay. What is the NCG's Transparency and Accountability Board for short TAB? Well, I would not answer this question directly, but I believe this could be answered indirectly through the historical background. Ano ba ang background nitong TAB? Okay. Well, hindi ko po ito creation, no? During the detailed planning and budgeting activity on August 24, 2022, the stakeholders of the Naga City Justice Zone identified and adopted the strengthening of trust and confidence in the justice system as one of its priority plans and projects or activities. And upon the suggestion and consensus of the judges present in the said activity, the NCGC adopted the suggestion to install a transparency board at the entrance of the Hall of Justice of RTC Naga for purposes of information, dissemination, and the promotion of public awareness regarding the accomplishments of RTC Naga in relation to its disposition of cases, which should be replicated by the other justice sector agencies such as the BGMP and the offices of the city and provincial prosecutor within the administrative jurisdiction of RTC Naga, including later on the performance of our PNP personnel. The transparency boards are actually not a standalone project. It should be complemented with suggestion boxes and the periodic conduct of the survey on the level of performance of RTC Naga City with the lawyers as the prospective respondents. Just to update, we're talking with the IBP CAMSOR chapters officers, and we're in the verge of finalizing the survey questionnaire. At the same time, to adopt a mechanism that the same be incorporated in the IBP app, but it is only accessible by the IBP CAMSOR lawyers. Now, the idea of the transparency boards actually originated from the practice of the Office of the Executive Judge, especially during my terms, in my earlier terms as AG, to publish on the bulletin board in our court the monthly pending cases of all first and second level courts of RTC Naga for purposes of effective monitoring and the promotion of public awareness how we dispose the cases. At pag may kakaroon ng judicial audit sa amin, we were recommended because for the judicial audit team, madali nila alam na kaagad yung pending cases, yung actual pending cases for the court to be subjected for judicial audit. So, yun po ang historical background nito. This is how the physical tab look like. Okay. And what are the data contained therein? No? At sabi ko, it is complemented with a suggestion box. Baka may sabihin that could help us how to improve our performance, our system. So, the data contained in these transparency boards are actually simple. Cases received for the month, cases disposed for the month, and the cases pending. In all courts, in all branches, in the first and second level courts, pag hindi ka nag-perform dyan, bakante. So, magtataka bakit wala. And somehow, it gives some psychological impact on the judges and, of course, prosecutors and private practitioners. Because, you see, the court operates with the help of the main justice sector actors, the prosecutors, the PAO, and the private practitioners. And ito yung mga suggestion na boxes. At present, we have 3 justice sectors, partners, which adopted this tab. We have the BGMP, the court, and the prosecutors. Medyo masilan lang sa prosecution's office dahil individual, pangalan nandyan. So, the cases received for PI and inquest and the pending cases are reflected in the Transparency Board of the City Prosecution's Office of Naga City. And on the part of the BGMP, we have here the Transparency Board, which reflect the total jail population, the classification, whether it's insular or city prisoners, and the number of PDLs committed for the month, and the number of PDLs released for the month. So, at least as judges, when we visit the BGMP, at least we know already the population and the clearance rate of the jail decongestion of BGMP Naga City. Okay. We're monitoring how we perform out of these transparency boards, the performance of each courts, individual courts. You see, the color orange represent the total cases received. And this is for the period January to October 2023. So, the blue one, that's the total cases disposed or resolved during that period, January to October 2023. And the green color represents the total pending cases for that period. So, from this graph, you can already see the profile of the performance of each court. Okay. And what is the clearance rate? Meaning the case inflow and the case outflow. So, for that period, January 2023 to October 2023, we received 3,489 cases. And we have disposed 979 cases, and we have still pending cases of 3,878. What is our clearance rate? Meaning the case inflow and the case outflow. And we have an 85.38% clearance rate. Of course, there are factors that you have to consider because we have 5 judges handling 2 courts, and yet we were able to produce this disposition rate. The ideal rate, of course, is 100%. Hopefully, if all the vacant courts in Naga City would be filled up, I think at least we can achieve our target, which is 100% clearance rate. So, what is, in essence, the Transparency Board? Actually, that reflects the performance of the main justice sector actors, the court, prosecutors, law lawyers, and private practitioners. Because in the case disposition, it takes 3 to tango. And they provide and promote public information. Transparency and accountability align with the SPGI's core principle of transparent and accountable justice. And what is the perceived expected result? We have here an increased public awareness about the accomplishments of RTC Naga, including the first level court. We perceive also the increased level of trust and confidence of the community in the judicial system and the courts, thereby effectively dwindling the public perception that justice delayed is justice denied, which is usually attributed to the snail-paced movement of cases or court proceedings, resulting in a public distrust in the justice system and actors, and more importantly, increased disposition rate made by highly motivated justice sector actors, thereby leading to court and jail decongestion. Of course, every day when you enter RTC Naga, that's the first thing that you will see. So ang hirap, titingnan mo yung disposition mo doon na medyo palaging konti. So in other words, the transparency boards, the transparency and accountability boards actually serve as a constant reminder to do better than last month. It's a constant reminder to work harder. And by the way, I don't know if this is the same feeling with other judges. It appears to have a psychological impact on us that we really need to improve. And at the same time, we feel a sort of a connection to the public that we're doing something, Because without this, parang blanco eh. These transparency boards are actually concrete, visible representations of the performance of our courts. So that's what we believe in this project. And eventually, this results to court and jail decongestion, because with highly motivated justice sector actors, maraming matatapos na cases, and it would result to releases of PDLs. And I thank the Chief Justice and Justice Singh for endorsing this to be in digital format, and MISO is already working on it. And based on our work plan, we target that by March 25 for our first broadcast, and at least 50% na yung time completed, and the percentage of tasks completed. And this is just a sample. No? We have been working with MISO on how it would look like digitally, which will incorporate other data from the prosecution service, from the BGMP, and perhaps later on from PNP. So, and also to ensure na hindi ma-postpone yung mga cases, we also proposed that the calendar of cases should also be integrated. Aside from the activities that we envision for the Naga Justice Zone. So yun ang contents nitong virtual platform ng transparency boards. Actually, behind this is really the commitment of each justice sector actors in the justice zone to really work hard. We have that also river of justice that we want to keep it moving, clean, unhampered, and unpolluted by corruption. In order to achieve our mission and vision aligned with SPGI's, which is to administer justice swiftly and fairly, worthy of public trust, as well as to improve access to justice for all. Swift and fair justice now in Naga. Marikas na hustisya, Naga na. Thank you. Diyos mabalos.
Thank you very much, EJ Farmaran. So our next speaker this afternoon is Executive Judge Marion Jacqueline Poblete, the convener of the Balanga City Justice Zone. EJ Jackie has been designated as the EJ of Balanga City for 4 terms and has been the convener of Balanga City Justice Zone since its launch last March 18, 2022 as the 8th Justice Zone. As such, EJ Jackie has guided the Justice Zone from its infancy, and under her very able leadership, has developed programs and activities which has led to a negative congestion rate for the Bataan District Jail. So let us listen to EJ Jackie as she discusses their initiatives, particularly their Bataan Cares program. EJ Jackie.
We start with the first slide. Your Honors, our distinguished guests and fellow public servants in the justice sector, Good afternoon. Special greetings from the family that cares. That's how we consider ourselves as a family. Okay. Okay, as Justice Ong mentioned, we are the 8th Justice Zone launched last March of 2022. And per our discussions, we agreed that the theme of the Balanga City Justice Zone would focus on the social justice aspect. So the theme of our Balanga Justice Zone is Hustisyang May Kalinga. Okay, that's the launch. Now we are very honored by the presence of our principals during the launching. It gave so much motivation and inspiration to all of the members and special members of the Balanga City Justice Zone that we decided to work hard and figure out the problems that can be solved while working together hand in hand. During our workshops, these 3 C's struck us actually. It's coordination, communication, and collaboration. And we made sure that we follow this to be able to solve certain issues and concerns within the Balanga City jurisdiction. Okay, because of that, we had the active participation of all of the agencies, actually. They are always present during discussions. The pillars of justice, from the courts, the City Prosecutor's Office, the Public Attorney's Office, the Bataan Parole and Probation Office, the Bataan District Jail and the Balanga City Jail, and the Balanga City Police Station. And we have also the active participation of the LGU. We are very fortunate to have their full support in our programs. We have the support of the provincial government, the Balanga City government, and the active participation now of the Balanga City Health Office and the barangays, the Association of Barangay Councils, and the Barangay Anti-Drug Abuse Council. And very important also is the full support of our integrated bar, Bataan chapter, and the Bataan DOH training, Treatment and Rehabilitation Center. I will just explain this later because they are very vital in the swift plea bargaining process on drug-related cases. And of course, the active participation of our City Welfare and Development Office. Okay, after the launch, since everybody was so inspired, we started meeting every Friday afternoon. Every Friday afternoon, after a week's hard work, everybody was looking forward to meet every Friday afternoon to discuss problems that we can address together. We started sharing information on the functions of each agency to be able to understand them and find certain ways how we can resolve certain conflicts among the agencies. And then we identified the problem that should be first addressed by the Balanga City Justice Zone. Of course, top of our list is drug-related cases and drug rehabilitation. Of course, the second one is women and children. Okay, we started sharing data on drug-related cases and drug rehabilitation. And by the way, we have converted my courtroom as a conference hall that is where we meet every Friday, and face-to-face and virtual. Thanks to GOJUST, we have an overhead projector. It makes us more looking forward to our meetings. Okay. These are the initial data, which is actually a representative representation of what is actually happening. For the regional trial courts of Balanga, most of the criminal cases filed in court were actually drug-related cases. I guess everybody is experiencing this. And most of the accused in drug-related cases filed would apply for plea bargaining and then apply for probation. And in most drug-related cases filed and heard on the merits, the accused were always acquitted. In the Bataan District Jail, most of the PDLs committed were those charged with drug-related cases. Most of the PDLs for drug-related cases are actually from Balanga City. You would understand that the more progressive a territory is, the more illegal activities are existing within. And this is what struck us. 45% of the PDLs for drug-related cases were repeat offenders. So actually, sa court talaga yan. You say, ikaw na naman. No? It's starting to be a vicious cycle. So we started finding for ways how we can resolve that problem. Of course, with the plea bargaining process, the cases were declogged from the courts, but shifted to the Bataan Parole and Probation Office and the DOH Bataan Treatment and Rehabilitation Center. So for the Bataan Parole and Probation Office, most of their cases granted probation were drug-related offenses. 20 to 40% of the probationers of drug-related cases completed and terminated their probation. Looking at the reverse side, 60% were not able to complete. So it's either they would serve the sentence or given another chance by the court. And most of the probationers are from Balanga. For the DOH Bataan Treatment and Rehabilitation Center, of course, most of the residents at the center are from Balanga City. And this is very important for us. Most of the residents are indigents. And there are many non-compliance of rehabilitation program. So this is exact picture of the vicious cycle that we encounter in drug-related cases. So we started discussing how we were to resolve the problem of drug addiction and decongestion of cases before the courts. And after a series of discussions on finding solutions, we realized that on our own, we could not resolve the problem because each agency will have its limits. Like if we acquit the accused, we're done. So the accused will go out, not rehabilitated. So it was then that we realized that we all need to collaborate for a holistic and effective approach to drug treatment and rehabilitation. How? We have to have the active participation of the community through the barangays, through the BADAC. So we created a coalition which we called Bataan Cares. It's a collaborative action for rehabilitation, empowerment, and support. Empowerment and support not only for our persons who use drugs, which we call PWOODs, but also empowerment and support of our barangay officials so that they can be guided on how they can act and react on certain, when faced with a situation of a constituent hooked on drugs. Okay, from there, the interagency coalition recognized the vital role of the community through the BADAC in the close monitoring and care of their constituents who are considered as persons who use drugs. The need to streamline and simplify the rehabilitation process and avoid duplication of programs for our PWOODs. Actually, the duplication is the probation and the treatment and rehabilitation center. The need to equip our PWOODs of the needed skills, training, and education to be productive citizens within the community. That's for the aftercare. And the need to provide employment and livelihood programs to enable the PWOODs to become self-reliant, self-sufficient, and independent. So our objective was a more effective drug rehabilitation program. So it's the utilization of the grassroots program with the participation of the barangay officials. And then we also would want to target easy access to judicial and legal processes, harmonize coordination among government agencies, jail decongestion, and decreased workload on drug-related cases. Actually, this project is just an ongoing project, but with a series of discussions, we were able to attain our goal. And the empowerment of the BADAC with assured support and training on the judicial and legal processes. So the drug rehabilitation, we classified into two. The existing one are those charged with drug-related offenses under RA 9165. On the judicial side, an accused charged with a drug-related case would enter into plea bargaining and would be required to undergo drug dependency examination. Now, since we have a DOH treatment and rehabilitation process, the plea bargaining process is very fast. No? In a week or two, we can get the results and we can proceed with the plea bargaining process. Most of those who entered into plea bargaining would apply for probation. No? And with the probation, they are required to complete the needed treatment and rehabilitation. The others who are not qualified serve their sentence, no, in jail. So this is where also the KKDK of the BJMP comes in. If the accused decides to go to trial because number one is no longer qualified for probation and wanted to take the risk, or he really wanted to prove his innocence, no, the accused will go to trial. Now, if acquitted, of course, the PDL will be released with no treatment at all. No? We also have a voluntary confinement for rehabilitation under Section 54 of RA 9165. This we are doing now with the assistance of the Public Attorney's Office in close coordination with the DOH Treatment and Rehabilitation Center for indigents, PWOODs. Once they get a court order, they can be rehabilitated at a very minimum cost. And then this we're trying to consider compulsory confinement for rehabilitation under Section 62 of RA 9165. And the IBP Bataan chapter gave their commitment, no, and offered their services in the filing of petitions. Of course, this will be in close coordination with the Dangerous Drugs Board for the proper accreditation. Now, those that does not go through the judicial process, this is our own ongoing project. This is the Bahay Pagbabago of the PNP, which we developed into a more holistic and effective program with the collaboration of the Balanga City Health Office, who have trained and accredited rehabilitation physicians and psychologists, and the Bataan Parole and Probation Office. And this program will have the active participation of the barangay, who we encourage to act as bodies of PWUDs who will be participating in the program. So this is a preventive move, no, for Bataan Cares. And all of this would function under the Bataan Cares Center. By the way, the Bahay Pagbabago program is free of charge. It's a 6-month program, but we have to assess the PWOODs if he is really determined to be rehabilitated. Otherwise, we will just let him go and see if we can bring him to compulsory or voluntary. No, because we are sourcing for funds for this. So we would rather help PWOOD who is really bent on being rehabilitated up to the time of his rehabilitation and aftercare. So these are the existing rehabilitation and treatment programs. The Bahay Pagbabago, the KKDK, and the Bataan Treatment and Rehabilitation Center, working hand in hand to resolve the drug addiction problem in the city of Balanga. Okay. So all these agencies had to coordinate with Bataan Cares so that we can monitor any releases of PWOODs. No, the barangay can monitor them and see if they can help one way or another, because we recognize that drug addiction is a lifelong disease. So the possibility of a relapse is always high. That's why in the Bahay Pagbabago, we will be having support sessions to remind them of the benefits if they quit a drug addiction. When we are going around the barangay, this was our slogan then. Hindi kulungan ang solusyon sa addiction sa droga. Hayaan mo na tulungan ka namin. Bataan Cares. Okay. Rehabilitasyon mo malapit sa puso ko. Magtulungan tayo. Bataan Cares. Okay. This is the proposed site that was allotted by the city government for Bataan Cares facility. No, this was originally intended as an isolation facility during the COVID, the pandemic, but was never utilized. So now we are converting it as a rehabilitation center, initially for drugs, but later on we can extend this to other addictions. Going around, it's like a hotel, actually, with aircon for each room, and we can accommodate 40 PWOODs. This is the actual facility that we are intended to have. No? This was prepared by the City Engineering Office. But it would cost so much for us to set up this complete facility. So we discussed with the City Engineering Office the minimum requirements that we can have just to proceed with our initial implementation of the program next year. No, and we decided to just put a multi-purpose structure in the middle. So the existing were the two structures. And this is what the City Engineering Office made for us. So we are now sourcing funds to be able to raise this multi-purpose structure fund. On the matter of sustainability, we also prepared a manual, because the issue of change of leadership might affect the program of the Balanga City Justice Zone. And with the help of GOJUST, they were able to make a layout of the manual and printed it, so we were able to distribute it to all the agencies and the different barangays of Balanga City. That was during the planning last November. Okay, we also have information dissemination, actually, pabalik. How do I go back? Sumubra na. Well, anyway, just, okay. Patapos na yata ako. Okay, for the barangay caravan, okay, we started information dissemination for the awareness of the constituents of Balanga City of Bataan Cares. Initially, when we were trying to discuss about the program, we invited some barangay officials to discuss with them the drug addiction within their locality. And at first, their understanding when it comes to drug addiction is that they will refer the matter to the police so that the person can be arrested. But after listening to our program, the result was very positive. No? According to them, they are now, their constituents now have the impression that they are there to help them rather than report them to the police. So we had the barangay caravan explaining again the program to them, where they gave their pledge of commitment. We also had a launch where we were graced again by certain officials that inspired us again to move forward. And then we had a seminar workshop of the members of the BADAC. It was a very happy occasion since they were very interested. In fact, we even had a role-playing as to how they are going to approach a PWOOD when faced by one. And we have also discussed the possibility of a barangay election, which happened last October 30. And we assured them that we will continuously train them. And we did last November 20 to 24, where the City Health Office conducted a community-based drug rehabilitation program. Okay, we also had PNP consultative meeting. No, this is very significant because, they get to realize the legal basis for the acquittal of their cases. So that helped also in the decrease in the number of drug-related cases filed. And we are fortunate also to have a DOH treatment and rehabilitation center with the help of the provincial and city government. And this is our Bataan District Jail. Actually, they just transferred last 2021. Although it can cater to 2,500 PDLs, they are currently occupying only half. No, and the other half was made as a training center for jail officers. This is how our jail looks like. Wala na sigurong gustong lumabas once they're inside. They are well taken care of by the provincial government also. So with the information dissemination and discussions, from 2016 to October 2023, in the Bataan District Jail, 80% of the PDLs were involved in drug-related cases. It jives with the data of the courts, 80% of the cases filed were drug-related cases. In 2018, there was significant releases of PDLs, 70% on drug-related cases. This was the plea bargaining framework and the implementation on the rule on continuous trial. For the courts, there was a significant increase in drug-related cases, but the highest case disposal. Now, following the rule on continuous trial, when I asked our jail officer what is the longest stay of a PDL in a drug-related cases, and he told me it's 3 months. So that is the data given by our paralegal who is here, Jail Officer Carlo Rimas. Okay, significant decrease in drug-related cases and increase in disposals also from January to October 2023. So most of the releases are due to plea bargaining. And this is now the congestion rate of the Bataan District Jail. It's negative. Negative 37 for the male, negative 68 for the female. And for the regional trial court, our disposal rate is more than the cases filed. So meaning those pending the year before were disposed also in the year after. So these are the percentage of reoffending, Some are for the 4th time, 5th time, At least it's from the 45% rate, it's now 35%. For the female, it's 30%, and it's going down. Now, worth mentioning is the significant contribution in the decongestion program of the jail facility is the efforts of the Bataan Peninsula State University through its extension training program, giving livelihood and skills training to all the PDLs. That's why we have here, I brought with me here, the president, university president of the Bataan Peninsula State University is Dr. Ruby Matibag. She's there. This is a program now ongoing, and it helps in the early release of PDLs due to the credit of time allowance for studying, teaching, mentoring, aside from the good conduct time allowances. This gave them also the opportunity to live, to have a livelihood even outside the jail. Okay, so these are the figures. Okay, and also special mention, our district jail was always commended, since for 2018, 2019 as District Jail of the Year. So that's it. Thank you very much.
Thank you, EJ Jackie. So now we go to our last speaker. I'm excited to introduce my kababayan, Executive Judge Retrina Espe Fuentes from the Davao City Justice Zone. EJ Reyna became convener of the Davao City Justice Zone in November 2022 and brings with her learnings and experiences from various justice sectors, having been a private practitioner, president of Dallas or the Davao City Lady Lawyers Association, a public attorney, a prosecutor, and now judge. So the Davao Justice Zone is very proactive and has several initiatives, not just focused on jail decongestion, but also on rehabilitation and reintegration of PDL. So a full package indeed. Let us listen to EJ Reyna as she discusses Davao City's draft ordinance on the rights of PDLs, rehabilitation of facilities, and their proposed manual on social protection programs for the PDLs.
So good afternoon, everyone. I'm the last speaker, but hopefully not the least. So sandali na lang ho ito, and then gala na kayo. Okay. So I would like to thank the organizers for giving us the opportunity to share with you our notable achievements and good practices in the Davao City Justice Zone on jail decongestion. Okay, so just a quick introduction of the Davao City Justice Zone. So the country's third justice zone, created through the Justice Sector Coordinating Council and supported, of course, by the European Union, was launched on March 14, 2019. As you can see from the slide, the opening of the Davao City Justice Zone was led by then Chief Justice Lucas Bersamin, with then Secretary of the DILG, Eduardo Año, and Justice Secretary Menardo Guevara in attendance, together with some EU officials as well as the former convener. So we have identified priority programs. These are the institutionalization of the Davao City Justice Zone, the Davao Swift Justice Program, the rehabilitation and reintegration of persons deprived of liberty. And under that category, we aim to strengthen the capability of the government to provide highly efficient, competent jail services, and through the combined efforts, coordination, constant communication, and collaboration of the members of the Davao City Justice Zone, we have enacted an ordinance defining the rights of persons deprived of liberty in Davao City, and we also formulated a manual on social protection for persons deprived of liberty and their families. So what has been accomplished by the Davao City Justice Zone so far? So in order to achieve these two decongestion initiatives, the manual and the ordinance, we had monthly meetings, not only to discuss the common concerns and struggles, but also to discuss how we can come up with the ordinance and the manual on social protection program for PDLs and their families. So, in this slide, we had technical working group meetings with the City Anti-Drug Abuse Council, of course the GOJUST, Ateneo de Davao University, and the BGMP on the preparation of the draft ordinance on the rights of PDLs. Also, there were separate meetings attended by all the members of the Davao City Justice Zone. During our monthly meetings, we deemed it necessary to create a TWG, or the Technical Working Group, for the drafting of another initiative, the Manual on Social Protection Program for PDLs and their families. That was on April 13, 2023. So I would like to add here that we also drafted a separate proposed ordinance, this time regarding the institutionalization of the Davao City Justice Zone. We have presented the draft ordinance to Honorable Justice Singh, which was approved, and the same was likewise presented during the National Justice Zone meeting last August 2023 as one of our good practices. This was duly acknowledged as replicable good practice worth emulating by the different justice zones. So the ordinance will be submitted to Councilor Lorenzo Benjamin Villafuerte as the chair of the Committee on Civil, Political, and Human Rights Council as proposed ordinance. So Councilor Villafuerte actually sits as one of the active members of the Davao City Justice Zone. He supports us all the way in our endeavors to decongest the jail as well as our other activities. So as mentioned before, one of the main initiatives and projects of the Davao City Justice Zone for jail decongestion is the rehabilitation and reintegration of persons deprived of liberty into society. So in order to achieve this, the Davao City Justice Zone was instrumental in the drafting of a manual on social protection program for PDL and their families. So to know the concerns and issues of the PDLs inside the detention center and to better formulate the ordinance and the manual, the Davao City Justice Zone, in coordination, of course, with the local government, conducted a legal aid caravan for PDL and a series of meetings conducted inside the BGMP facilities. So after we have finalized the ordinance defining the rights of persons deprived of liberty in places of detention in Davao City, we lobbied for its support as proposed ordinance to Councilor Villafuerte. Okay. So Judge Rowena Adlawan, the acting executive judge, recently held a brown bag discussion on the draft ordinance on October 2, 2023, with, of course, Councilor Villafuerte, who will sponsor the draft ordinance. Okay, so what is Resolution number 2023-001, Series of 2023? So it's a resolution signed by all the members of the Davao City Justice Zone, calling the support of the City Mayor and the Sangguniang Panlungsod to enact the ordinance defining the rights of persons deprived of liberty in places of deprivation of their liberty in Davao City and providing funds for their enforcement. So we attached already a copy of the ordinance in our resolution, and we will submit the same to Councilor Villafuerte for the committee hearing to defend our position on the matter. So, okay. So, what is our ordinance? Let me walk you through some salient provisions of our ordinance. So at first, the Davao City Justice Zone deemed it important to pass an ordinance that will promote the general welfare and safeguard the basic rights of every persons deprived of liberty. And by promoting and ensuring the reformation and social reintegration, creating an environment conducive to rehabilitation and compliant, of course, with the United Nations standard minimum rules for treatment of prisoners, or the Mandela Rules. The ordinance provides for different categories of PDL upon admission to facility, taking into account their sex, sexual orientation, and gender identity, and expression, their age, their criminal record, the legal reason for their detention, and the necessities of their treatment. So, in our ordinance, we categorize 3 PDLs. The first is, of course, the men and women. So far as practicable, they should be detained in separate institution. So we also provided the persons with diverse sexual orientation and gender identity and expression. They shall also be entitled to a separate detention facility. The children in conflict with the law shall also be kept separate from adults. Okay, so The ordinance seeks to protect the rights of the PDLs on the following. First, the accommodation. So under our ordinance, all accommodations provided for the use of the PDL and sleeping accommodations or their place of rest shall, as much as possible, meet all requirements of health, due regard being paid to climatic conditions, cubic content of air, minimum floor space, lighting, heating, and ventilation. There shall also be a regular supervision by night in keeping with the nature of the places of deprivation of liberty. Okay. Next is the hygiene and health. So for the hygiene and health, we refer to women deprived of liberty as WDL. And we specified in the ordinance that they shall have facilities and materials required to meet women's specific hygiene needs, including hygiene packs, sanitary napkins, and others, soap, shampoo. This shall be free of charge, and a regular supply of water to be made available for personal and child care, and those who are pregnant, breastfeeding, or menstruating. Okay. So for clothing and bedding, the ordinance provides that all clothing shall be clean and kept in proper condition. Underclothing shall be changed and washed as often as necessary for the maintenance of hygiene. For the food, of course, every PDL shall be provided by the jail and detention rehabilitation facility administration at the usual hours with food of nutritional, that is important, of nutritional value adequate for health and strength, of wholesome quality and well-prepared, and respecting PDL's religious and cultural requirements. For exercise and sports, of course, the ordinance provides that it shall have at least 1 hour suitable exercise in open air daily, if the weather permits. And safety and security. The most important part of this provision in safety and security, the searches or the personal searches of the PDLs shall be carried out only by the staff who have been properly trained, appropriate searching methods, and in accordance with the established procedures, taking into account the gender of the PDL and the places of detention of employee carrying out the search. So, contact with the outside world. Is the contact with the outside world allowed? Of course, it is necessary under necessary supervision to communicate with their family at regular intervals. We also provided here that correspondence in writing, telecommunication, electronic, digital equipment, and other means shall be used by the PDL. And of course, receiving visits is a must for PDLs detained in Davao City. So, next. Religion. So for religion, we provided that every PDL shall be allowed to satisfy the needs of his or her religious life by attending the services in the jail, detention, and rehabilitation facility, and having in his or her possession the books of religious observance and instruction of his or her denomination. For the retention of PDL's property, of course, this shall be kept by the persons in the places of detention by the authorities for safe custody. So once released, this article shall be returned to the PDL. Searches of PDLs in detention areas, this, as I said earlier, it shall be provided, or it shall be done by the persons very well trained to conduct the searches of PDLs in their detention areas. So we also provided a provision on discipline. And of course, in case of death of PDLs, in cases where there are allegations of torture, the body should be preserved and an autopsy should be conducted. So notice also should be given to the Commission on Human Rights as to the cause of death. Okay, so for aftercare and reintegration, we provided here that the place of detention authorities or the jail authorities or rehabilitation authorities in cooperation with the probation and or social welfare services, the local community groups, and the non-governmental organization, they shall design a program or comprehensive pre- and post-release aftercare and reintegration programs, which take into account the needs of the PDL and the gender-specific needs of women detained, women WDL. So how do we reintegrate the PDLs into the society? So in our ordinance, we provided that the places of detention authorities shall utilize options such as halfway houses, community-based programs, and services to the maximum possible extent of PDL to ease their transition from places of deprivation of liberty to reduce stigma and to reestablish their contact with their families at the earliest possible stage. We also provided that additional support following the release shall be given to the PDL who need psychological, medical, legal, and practical help to ensure their successful social reintegration and cooperation with services in the community. Okay, so that those are the salient provisions in our ordinance. Let's move on to the formulation of the manual on social protection program and their families. So as you can see from the slide, there was a write-up on the said manual on April 14, 2023. Okay. As well as on June 15 to 16, participated by the members of the Davao City Justice Zone and law schools in Davao City. So, in order to carefully craft the manual, the TWG met again on September 5, 2023 to discuss the contents of the manual. Okay, so just to give you a brief background on the manual we have painstakingly formulated. So in cases where PDLs are incarcerated, their families are left behind with no protection, support, and program. So it is for this reason that the manual, as well as the protection programs and services, are devoted not only for the PDL, but extended to their families. So the manual likewise underscores that social protection for PDLs and their families should be anchored on the fundamental human rights principles and mandates to ensure their well-being, dignity, and successful reintegration into society. So the social protection programs and services for PDL contained in our manual are the following. First, the adequate living condition, the healthcare services, mental health support, legal assistance, communication with the outside world, family visit and support is a must, education and skill development, vocation training and employment opportunities, spiritual support, aftercare and reintegration support, poverty alleviation program, social alleviation, crisis intervention, assistance in CSSDO documents, and we also included here the referral in medical, legal, financial, education, and training. So our manual was validated already by the members of the Davao City Justice Zone during its meeting on October 6, 2023. So after completing all these initiatives, the ordinance and the manual, which the members of the Davao City Justice Zone helped in the drafting, we will have a soft launch of the program, pilot testing, and recalibration and printing of the manual. So, let me just share with you the upcoming activities of the Davao City Justice Zone. Anyway, these activities also involve the jail decongestion. So for our upcoming activities, we partnered with the local government unit in the implementation of its Davao City Swift Justice Program. It is a program initiated by the local government, which we seek to partner with them. And it aims to assist the courts in improving the administration of justice by addressing issues therein, such as the clogged dockets, and ensure that all pillars of justice work together to promote justice and dispose the cases expeditiously. So we all know that we lack manpower to help us in the dispensation of justice. So this program of the local government will help us in the hiring of contracts of services or job order employees to the courts, and also it supports the PAO, the prosecutors, the probation officers, and the law enforcement agents in its capacity building to help them improve their services. So the Davao City Justice Zone also created the PROLEC, or the Prosecutors, Law Enforcement, and Courts Committee on Jail Decongestion, by training the police officers and for the effective service rendered by our police officers. So this is the initial project of the PROLEC. In Davao City, we conducted a capacity building for 3 days to our police officers in Davao City. And this was successfully conducted last month, just recently. Also, we also recently concluded the drafting of the manual, a memorandum of agreement between the Davao City Justice Zone and law schools, increasing the membership of the Davao City Justice Zone to include law schools in Davao City, with the intention to maximize the potential of law student practitioners and involve them in the programs of the Davao City Justice Zone, particularly the decongestion activities as well as the court dockets. So we included in this signing the deans of the 5 law schools, the Ateneo de Davao, the University of Mindanao, the Rizal Memorial College, the University of Southeastern Philippines, as well as the Jose Maria College Foundation participated in the signing of the MOU. Actually, the MOU was forwarded to Justice Singh for her approval, and she approved the same. And so we recently had that contract signing with the deans of law schools last November 28, 2023 at Seda Hotel, in line with the team building activities of the Davao City Justice Zone. So with all these initiatives and policies, programs of the Davao City Justice Zone on jail decongestion, I'm so lucky as convener that we have active members who continuously participate in all our activities. So a large part of the success of the initiatives of the Davao City Justice Zone comes from the huge support of the members of the Davao City Justice Zone who cooperated and gave their unselfish time and efforts to our activities. Hence, with the active participation of the members and the strong support of the LGU, our shared goals are bound to succeed. We rarely work alone, but we collaborate together to achieve our decongestion initiatives. Thank you so much for listening.
Thank you so much to our speakers, EJ Farmaran, EJ Poblete, and EJ Reyna. So I think we do have some time for questions. We've heard from their very good best practices, which we hope can be emulated by other justice zones. So if you have some questions or clarifications on their presentation, we can have some time for you to raise them to our panelists. Ay, yes po. Please identify yourself and your organization and raise your question.
Hello, good afternoon. Really very encouraging to listen to the innovative and proactive approaches in the justice zone. My question is, sorry, yes. I'm Attorney Cristina Sevilla. I'm with the OMCT, World Organization Against Torture. Yeah. So, my question is more specific to the visitorial power of the courts. And of course, we have some agencies, the national agencies such as the CHR, doing the monitoring, and then it's under, of course, it's under the RA 9745. And with respect to monitoring of detention facilities, the challenge, really, one of the biggest challenges is unannounced visits. I am curious to know, with respect to your practices, do you think this can be done? Do you think it's necessary? And if it is, do you think it can be done? Considering that the courts has a more or less localized interaction.
Okay, as to visitation, actually, we are mandated actually to regularly visit jail facilities. And with the Justice Zone, we are regularly in touch with the jail officers and officials of the BJMP to ensure that the facilities are okay for our PDLs. So, I guess with the Justice Zone, there is always room for improvement. And that in the discussions also, the BJMP is always part. And when in the discussions, there are other concerns also. So we raise that during the meetings.
Oh, yes, we regularly go to the BJMP. In fact, I think sawa na sila, Rovian, sa mga mukha namin doon because we always go there. And the reason why, because we are also mandated by the Supreme Court to regularly visit the jail facilities. Plus, we have the ordinance and the manual. And we want to know the concerns and issues of the PDLs. That is why we are always there. We conduct meetings there so that we can include in the manual the concerns and how to address them.
Actually, just to add, we received a letter from the CHR on the concerns on video conferencing. They were requesting if we can go face-to-face with the PDLs because the problem is that they could not discuss lengthily with their lawyers. So on our part, we tried to bring them in court and try to lessen the calendar so as not it would be crowded in court. So those are the things that the courts can do. Thank you.
I heard about whether it is possible for an announced visit. As I've already been mentioned, it's really within the powers of the executive judges to have a regular visits because that is mandated by the rules. Now, it depends upon the executive judge. If he believes, or if he or she believes that there is a need for an announced visit, I believe it can be done. But with the Justice Zone sit-up, we are in constant communication with the jail wardens and their focal persons so that we know their problems. And so that's the reason why Justice Zone exists. as we communicate, coordinate, and collaborate whatever problems that they're encountering and find a solution.
Okay. Thank you
Thank
to
you.
our panelists. I think we have time for one more question. Okay, so if we don't have any questions, so let's wrap up. As you have heard, the justice zones are very effective and provide avenues for holistic or whole-of-government approach to understanding the problems and finding creative solutions to these problems. So as we've heard earlier, the 3 C's are really important: communicate, collaborate, and coordinate with each other. So from EJ Formaran, we heard on how the increased trust and confidence in the community in the judicial system was done through the TAB project. And of course, these TAB projects is also a constant reminder to the members of the justice zone to do better next month, to work harder and do better every day. And from the programs and projects of the Davao City and the Balanga Justice Zone, we've really seen how the constant coordination, communication, and collaboration worked towards their goal of jail decongestion and towards reintegration. As you've seen from all their slides, they're always meeting for Balanga City Justice Zone every Friday and monthly for the Davao City Justice Zone. So we've seen the best practices of our justice zones, and I hope that you've all learned a lot from the practices and you can bring them with you in your own cities so that you can emulate them in your own justice zones. So with that, we end our workshop number 8. Thank you, everybody, and see you tomorrow. Thank you. Thank you to our panelists. Thank you.